Hello, and welcome to our latest show of From the HRC, a program from the Township of Lower Merion's Human Relations Commission. I'm Harold Goldner, former chair of the commission, and my guests today are Jamie Williamson, Regional Director of the Equal Employment Opportunity Commission, and Mary Tiernan, Outreach and Education Coordinator at the EEOC. Jamie and Mary, welcome to From the HRC, and thanks for joining us.
Thank you for having us.
Jamie, I understand that despite landing here in Philadelphia with this responsibility for the EEOC, you hail from New England.
That's correct. Massachusetts, to be exact.
Tell us a little bit about your background, because I know you did some very interesting work up in Massachusetts before coming down.
Yes. So prior to my moving to Philadelphia, I was the chairwoman of the Massachusetts Commission Against Discrimination, and that was the equivalent of an HRC. It's a state agency that actually does the work that's similar to the EEOC, except that it includes employment, it's housing, public accommodations. So we cover a little bit more in terms of civil rights. So we're actually the enforcement mechanism for the civil rights for the state of Massachusetts, which is under Chapter 151B, a little bit different, as you know. There's states' laws versus the federal laws. And so I was appointed by the governor back in 2013, I believe, to be the chair. And prior to that, I was a commissioner appointed by him in 2013 as a commissioner for the Western Massachusetts part of that state agency. So I'm originally from Pittsfield, which is Berkshire's, Western Mass, where we think we're actually part of New York, until that governor came along and said, hey, you guys, you can join the state. So Western Mass joined in, and we became part of the whole state. And we did work, the majority of the work was, again, EEOC has a very large contract with most of the HRCs, and that's usually the majority of cases that you see, as well as the housing and public accommodations. And we had some wonderful work that was done over that period of time. And the thing with Massachusetts State is that they kept expanding the protected categories. I think in my time, we expanded it 4 more additional categories. And then right before I left, another 2. So this work is evolving in terms of who is protected, as you can see in some of the landmark cases that have just happened recently. For example, in Bostock, which we just celebrated the anniversary in June of, right, is including transgender and ensuring that sexual orientation and transgender become part of the protected categories for the federal side under EEOC's compliance. And before that, I actually worked in just straight fair housing. Before that, I ran my family business, a retail business. So I've done a myriad of different things, and I think I've been in almost every industry there is in terms of type, whether it's state. I was also the first African-American woman to sit on the city council in my hometown of Pittsfield, Massachusetts. And very interesting because that was in the 90s, and I felt like that should have happened before then, but I was glad to be a part of it. So being a part of history is always interesting. And it's definitely something that you take with you in the experience of the work that I did.
Yeah, I remember from my own time while I was in law school working with some of the Pittsfield local officials, and it was a different environment there. But that said, I can tell you, having driven and spent some time in Pittsfield, as soon as you cross over from Troy, you can tell you're not in New York anymore. You're in Massachusetts.
That would be correct.
You absolutely can feel that. Mary, tell us a little bit about your background and how you found yourself at the EEOC.
I stayed local, unlike Jamie. I grew up in the area, went to Villanova for undergrad and for law school. And I went to law school with, these ideas that I wanted to help people. I didn't know what it meant, but I just wanted to go work for the government and help people. And I was very fortunate. I had an amazing employment discrimination class, then Professor Langto, and like, this is what I want to do. And I had an internship with EEOC. After my second year, when I graduated, I had a clerkship with a Court of Common Pleas judge. And as that was ending, I was very fortunate. There was a position available as a trial attorney. I applied, was selected, did that for several years, and really enjoyed that opportunity. Working with the investigators, we're neutral in the investigation. We get information from the person who thinks they've been discriminated against, get information from the employer, and hear both sides of the story. during the investigation, attorneys can work with investigators on some cases, give advice or answer questions. If we determine one of our laws was violated and we can't, what we call it, conciliate it, work it out voluntarily in an administrative process, in some cases we file a lawsuit in federal court. So to the advocate side to vindicate the public interest against discrimination. And very fortunate to do that, worked on very interesting cases. But for me, a certain period of time in litigation was like, that was good, but what else was out there? And this outreach and education opportunity came up several years ago. And I like this because I like to talk to people and try to give people the tools to work things out in the workplace, but letting them know that EEOC is here if they can't resolve it, and we're willing to and able to do investigations and see if any of our laws were violated and try to work situations out that way.
So you're still an advocate, you simply don't have an adversary, which is the right way to do litigation, in my opinion.
Right? The recovery is, I think, an attorney's dream for many attorneys to, get to talk about the law without actually having to go into court, talk about the wonderful things that Jamie and people in enforcement do, or that our attorneys under our regional attorney, some of the great victories or resolutions they've had. It's one of the best jobs you can have out there.
That's great. Jamie, I've had the opportunity to have the acting director of the Philadelphia Commission on Human Relations, and I've had people from the Pennsylvania Human Relations Commission. Can you explain to our viewers how the relationship between the local, the state, and the EEOC, how this hierarchy of agencies works in enforcing anti-discrimination laws?
Right. So, like I was saying earlier, is that the individual or the state agencies are generally working under the rubric of their state anti-discrimination laws. So they're funded in part by their state legislatures. And what they have with the EEOC is a work share agreement, much like a contract saying, you will perform this much work for us on our behalf, and then we will reimburse you for that work. So you're doing it under the guise of usually the state agencies, particular state laws, and in some cases where it's not a state agency, but something that may be considered a local entity that's regional. For example, like Boston has its own version of an HRC on top of the state agency. And so those operate usually within the context of having some kind of contract with the federal government, whether it's EEOC or HUD, and then a combination of either local resources from the city that they operate in or the state that they operate in.
I know that when our own commissioners enacted the ordinance we have here in Lower Merion Township, they were very concerned that people who came to the Lower Merion HRC with a complaint did not somehow void or miss their opportunity for any claims they would have under state or federal law. And I know when we crafted our regulations, we made sure that everyone who files a complaint with the Lower Merion Human Relations Commission is given a page that tells them, for example, if you have a federal housing matter, you should complain to the Housing and Urban Development. Don't lose that opportunity. The same thing for protected classifications that are covered by Title 7 of the Civil Rights Act and that the EEOC handles, or the Pennsylvania Human Relations Act. I think, though, that some of the local agencies only have the ability to mediate when it comes to them. And I understand that the EEOC has a lot more power than merely, and the EEOC has a fabulous mediation program, which I've participated in, representing both employers and employees. It's an absolutely incredible program. But the EEOC can do a lot more than just mediate. You guys actually investigate and talk to witnesses and so forth. Can you just briefly outline that for us?
Okay, so also some of the HRCs that are the state agencies have the same ability to do what the EEOC does. So I want to be clear about that. In state agencies, they have the ability to what we call adjudicate. So it's investigate, adjudicate, and educate. Those are usually the three prongs in most of the entities. And then, within that rubric, they will also do ADR, which is alternative dispute resolution. I like to call it that because what I'm always looking for with the HRCs is to ensure that they are also getting public interest into their agreements. I think that's really important, right? Ensuring that the business is going to change its policies, practices, or procedures so that they're in compliance with the laws under which that case was brought against them, and or to do different things. So depending on what it is, whether they have, to pay somebody for the discriminatory activity, and then other things. And so they all have that. So in Pennsylvania itself, there are a couple of HRCs that actually have the ability to adjudicate cases. So when you're adjudicating, that means you're actually doing from the investigatory spot, which is we come in, somebody does an intake, we talk to them about what they believe they were discriminated against. Then after that intake is done, there's generally a determination made whether or not we're going to move forward and do some more investigation. We may ask for a position statement from the responding party. That would be the business that the person is seeking redress from. And then after that, if we find cause, we can issue a cause finding. In the EEOC side, then you go into a conciliation, right? The ability to conciliate prior to then having to take it to another level. And we're always, and I think it's very important to say this, we are always trying to resolve the issue prior to litigation. No one wants to litigate. We want people to come to the table and do the right thing and to do something that's collaborative, because I think that's a better way to move the civil rights ball, but sometimes we can't do that. And in that case, then we just straight out go to litigation and let the courts decide. But HRCs in some cases have the same ability to do that same type of work. But we do encourage ADR everywhere we can, and I'm a big proponent of that. I make sure that that's embedded in everything, in every agency that I work in. ADR is part of that process.
I agree. It's been my experience, and I speak as a litigator with 40 years of experience, that my appetite for litigation is never the same as my clients. And my clients, for them, every time I call, they're reminded of, oh, that case. It's sort of like if your dentist is calling you on a regular basis about that root canal you forgot to get. You just don't want to hear from them. And you learn that a resolution is better. A negotiated resolution is always better. Well, we have to take a break right now, but we'll be right back with more from the HRC with Jamie Williamson and Mary Tiernan from the EEOC. We are back with From the HRC. I'm speaking with the Regional Director of the Equal Employment Opportunity Commission, Jamie Williamson, and Mary Tiernan, the Outreach and Education Coordinator for the EEOC. When we left off, we were talking about the comparative roles of local HRCs and state HRCs and the EEOC itself. We here at Lower Merion have an ordinance that provides for not only mediation, but also investigation and adjudication as well. And a lot of the local HRCs have had to deal with the situation where they only have a 4 or 5 member commission. And if they're going to end up adjudicating, they may not have enough commissioners to actually finish the task. In our experience in the last 10, almost 11 years now, we've never had a matter go past mediation. And one of the things our Board of Commissioners is, sort of likes to say is we offer our township residents a free mediation service, and that's what we've been doing, is mediating these, and fortunately haven't had to investigate. I've thought about being in the unusual role of investigating claims, especially as somebody who's prosecuted them and defended them. So objectivity is really critical. One of the things we learn is that there's adverse impact when somebody's fired because of their race or because of their sex. But there's also something called disparate impact. And we read about a lot of writers who talk about policies or situations that happen that seem to be neutral from a discrimination standpoint, but in fact have a discriminatory effect. How has the EEOC, Jamie, addressed disparate impact types of matters?
Right, those cases are pretty much along the same lines of what we do on even in individual cases. So disparate impact versus the adverse impact when you're looking at a large group, right? That it's one, but it's one of many. So it really does follow the same patterns. The only thing that you would be looking for is how many more people it impacted. So, for example, if I were to bring a case forward and say that I didn't get promoted, and I believe that the policy that they put into place gave me a disadvantage, right? That I had a disadvantage because of a policy that seemed neutral. Like, for example, that you couldn't have a break in service. Let's think about it this way. So in order for you to be able to be advanced, you can't have a break in service. You have to have 3 consecutive years of being in a position before you're given an opportunity to have a significant advancement and or to even have access to maybe training that gets you there. I'm a woman. Let's assume for the sake of this story, I'm in childbearing years. and to that end, that would be a disparate impact, right? Because in fact, it seems, like you're trying to, it sounds like a good business reason. Well, look, we want people to be in there a certain period of time. We want them to go through these step processes. We don't want to have a break in service. But ultimately, for a woman in a certain age group, that could potentially end up where they're being penalized for being in childbearing years. And therefore, that does have an impact on them. So then how many of them would have been impacted during that period of time in which that policy was in place? So that's how we look at it. So it usually starts with one entity or maybe a group of people that come in and say, we're not given this, or we weren't given an opportunity for X. That way you'll find it. Now, there are other ways that you look at some of this stuff, and it would be a statistical analysis, right? What's the expectation? Given X, Y should occur, given, Z, X should occur. And so there's a balance that when we're doing an investigation, that we will do some statistical analysis to see, does this make sense? Would that have happened? And when you look at it that way, that will also help fashion some of the way that we investigate and the ways in which we look at it to demonstrate that it did have an impact, right? How many people did not have an opportunity because of. And so they're different, but they're, because we're investigators, we can investigate anything. And it's just different tools that you would use and different, and the number of people that may be impacted, right? And so you see it in those cases, that's just much a part of, when I think that Ibram is having a conversation about that, they're trying to talk to you about systemic, what's inside, what is part of the culture, which is not, just because somebody made a policy, it may not necessarily go to that level. And I want to be clear about that we can't just, I think that today we're looking at these big, broad brushes of things, right? There was a policy in place. Well, the policy, somebody thought that was a good policy because they were trying to get somewhere else. And in trying to do that, that's where the misstep is. You see that same thing when you're looking at housing, right? We want to make sure that everybody has the ability to pay, but we forget that some people are retired, some people are on disability, some people have money without having to work. So oftentimes these policies are really more about saying it wasn't well thought out. It didn't understand. It didn't go further enough, or it wasn't tested enough to determine what impact it would have beyond what they thought they were trying to achieve. And I think that's what you see in a lot of those cases is just, hey, we thought this was a good thing to do because it made sense. But then when you play it out, it doesn't. And it impacts people who are in those protected categories, already marginalized and already have the whole time.
Mm-hmm. The result of unintended consequences.
Exactly.
Speaking of consequences, about a year ago, you mentioned this earlier, the Bostock decision, the Supreme Court, the United States Supreme Court decided that because of sex also means because of gender affinity, gender identification. And I know the EEOC had some guidances about this before Bostock. How has Bostock impacted how the commission has handled sex discrimination cases in the ensuing year?
I would say that not very much different, all things considered, because I think we were taking the sex as that. What happens is oftentimes is that when the Supreme Court rules, then what we did has been affirmed. And I think that's what we were looking for, is that affirmation of saying, okay, there's no question anymore, right? You can appeal our decision. You can't. In this case, it's now we don't have to worry about it. It's been made law. We understand it, and that there'll be no more discussion. But I think early on, and I would say even back to maybe as early as the 70s, and Mary, you were in there before I was, in terms of maybe having a conversation on how we did gender. But I know in the state of Massachusetts, gender anytime sexual orientation, any issues around gender where there is an expectation, right? The gendering of different groups of people. And, and I joke and I say I'm an example of that, right? I have an androgynous name and an androgynous voice. So people oftentimes don't get, they'll call and think that they're talking to a man. And so sex has always been part of that, right? Is that what do you expect to hear? What do you expect to see? How do you expect us to act? And so we assume that those are those gendered roles, and ultimately they are covered under sex. And so I think historically we have done that, but now the Supreme Court says yes, that's okay to do.
Yeah, I would say on our agency end, it probably was about 2012 when we, looking at case law, looking at the trends going, that we began to recognize that the protections against sex discrimination included sexual orientation and gender identity. In our district, under our regional attorney, Deborah Lawrence, we'd filed some of the first lawsuits alleging that sexual orientation discrimination violated Title VII. They resolved. So we had been, as Jamie said, we've been processing them, and we're continuing to try to do outreach to help individuals and employers know about their rights and responsibilities, and so everybody can have an inclusive, welcoming workplace.
Yeah, my recollection was the first case sort of in the subject matter was the Macy case, and that was when the EEOC took and tried to make a point on. That's what I remember.
Yeah.
So in the time we have remaining, there's one other thing the EEOC does that I don't want to avoid, and that is you guys, you issue guidances and real help to both employers and employees in how to sort of navigate the waters of anti-discrimination laws. And I was quite impressed with the way the EEOC responded to the pandemic with guidances on how do you respond to proof of vaccination before there were vaccination? How do you respond to somebody who's got a susceptibility? Could you take a little bit of the time we have remaining and talk about the EEOC guidances?
Harold, if you don't mind, right before, I want to let Mary actually answer that, but I do want to say this because I think it's important to say for those who are watching or listening, is that the EEOC is not just for the person filing a complaint. They're a resource for businesses. As a matter of fact, if you go on our website, you'll see that we actually have a small business area website that you can go in and gather information, that you can get the facts, because small businesses oftentimes don't have a human resources. They may be small in nature, may need some information. All of that information is available online at the EEOC. So, I want us to be mindful that we're not just the compliance bad guy after the businesses, but we're here to help and serve. And so I think that's important to note, that you can go on to our website, and I encourage everyone to go on and look. There's a plethora of information. And I'm going to turn over to Mary to talk about all that information, including our COVID.
That's a great point, Jamie. Go ahead, Mary.
Thank you, Jamie. So, and thanks, Harold. I do think that the Commission tried to move quickly and respond to unprecedented times to help employers and individuals navigate what we've gone through as a country in the last year. And on our website, we have keep updating the what you should know document, gave them information to employers on how they could handle employees returning to work, giving guidance on that. Now with vaccines, our laws do not require employers to require vaccinations, but they don't prevent it, as long as, it's an employer's discretion, as long as employers make sure that they give reasonable accommodations if requested because of disability. That can include if it's pregnancy-related impairments or religion, unless the employer can show it's an undue hardship. And some of these things with undue hardship, also looking, are there alternatives to keep the person employed if somebody cannot get an accommodation, maybe perhaps for a pre-existing health reason. And we really tried to address it very comprehensively on the What You Should Know document. I believe after the program, you'll have the link there that brings people right to that page. I'll also like to highlight, we have a new landing page for issues on protections for individuals, members of the LGBTQ+ community, to ensure that there's no discrimination based on sexual orientation or gender identity. So we'll highlight that little webpage. It's part of, as Jamie said, our outreach to everybody. We really want to help everyone know about their rights and responsibilities and be a resource for the employer and the employee and advocacy communities.
Well, Jamie and Mary, I am so glad I was able to catch you in the middle of your busy schedule. I understand there's a national conference this week that I got you out of, and I'm so glad you joined us today. I look forward to seeing you again when live meetings return to the world. And I want to again express our thanks from the Lower Merion Human Relations Commission for joining us this month. And thank you, viewers, for joining us on From the HRC. We look forward to seeing you next month on our next program.